For centuries, contract law operated on the premise that parties were free to agree to almost anything, bound only by their word and the strict enforcement of the courts. Today, in South Africa, that absolute freedom shatters upon contact with modern regulatory law. In the first part of your legal training, you studied the general principles, how an obligation is formed, breached, and terminated. Now, we examine the mechanics of specific agreements, focusing on the contract of sale and the contract of lease. Analyzing these specific contracts requires navigating a constant tension. You are balancing Roman Dutch default rules against specific statutory interventions. This three-tiered pyramid shows our analytical framework. The foundation is the common law. This layer dictates the essentialia, the vital elements that identify the contract, and the naturalia, the default terms automatically attached by law. The middle tier introduces statutory overrides. Legislation like the Consumer Protection Act and the Rental Housing Act overwrite those historical defaults. At the apex sits the Constitution, which infuses all agreements with the imperative of Ubuntu, reasonableness, equity, and good faith. Legal scholars like Fouché and von Hustine map this terrain, providing the doctrinal baseline for how these three layers interact in practice. Because these layers interact in real time, relying solely on Roman Dutch common law provides an incomplete legal picture. Modern practitioners must filter every agreement through all three tiers of this framework. Before you can assess liability or enforce a warranty, you must identify the specific category of the agreement. The line between a contract of sale, emptio venditio, and a contract for services, locatio conductio operis, is often blurred in commercial transactions. The test for this distinction comes from the 1986 Appellate Division in Westinghouse Brake and Equipment versus Bilger Engineering. The dispute centered on a contractor hired to supply and install specialized industrial equipment. The court had to determine if the parties had concluded a sale of goods or a contract for labor and materials. The court ruled that classification depends on the true intention of the parties. If the dominant purpose is the transfer of the finished product, it is a sale. If the dominant purpose is the skill and labor required to create or install it, it is a contract for services. This distinction dictates which default rules apply. A contract of sale automatically triggers specific implied warranties, like the warranty against latent defects, which do not apply to a service contract. Misclassifying the agreement at the outset alters your entire litigation strategy, directing you toward the wrong remedies and legal arguments. This blueprint of a sale maps three critical nodes: delivery and risk, eviction, and latent defects. We'll focus on the first, the passing of risk. Who bears the loss if the item is damaged after signing but before changing hands? Under the common law rule established in Bozeman Brothers versus Van Niekerk, the risk passes to the buyer the moment the sale is perfected. Once consensus is reached on the item and the price, the buyer holds the risk, even if physical delivery hasn't happened yet. This vulnerability for the buyer is the reason the Consumer Protection Act introduces statutory overrides that alter the default rules for commercial sales. Section 19(2)(c) of the CPA reverses the common law position. In consumer transactions, the risk of loss remains on the supplier until the goods are actually delivered and accepted by the consumer. We then pivot to the second node, the implied warranty against eviction. In Lammers and Lammers versus Giovannoni, the court emphasized the seller's duty to protect the buyer's undisturbed possession from third parties who might claim a superior legal title to the property. The final node involves latent defects and the Voetstoots clause, buying property as is. At common law, the standard to defeat a Voetstoots clause is high. As confirmed in Odendaal versus Ferraris, a buyer must prove that the seller not only knew about the hidden defect, but deliberately concealed it with the intention to defraud. The CPA provides consumers with a specific defense against standard Voetstoots clauses through Section 51(1)(b). This section prohibits any contract term that defeats the Act's purpose or forces a consumer to waive their fundamental right to safe, high-quality goods. Van Hystine notes that this moves the legal standard away from private agreements and toward public policy enforcement. You cannot hide behind a standard exemption clause if it violates these statutory requirements. In modern consumer sales, the state actively polices substantive fairness, effectively limiting the scope of the historical caveat emptor rule. This blueprint of a lease applies the same structural logic, mapping three distinct nodes: undisturbed use, remission of rent, and security of tenure. The lessor's primary legal duty is providing commodus usus, the beneficial use and enjoyment of the property. The 1956 case of Saffiantini v. Mold solidifies this. The landlord has a strict common law obligation to guarantee the tenant's possession won't be disturbed by the landlord themselves or anyone acting on their authority. But what happens when that undisturbed use is destroyed by outside forces beyond anyone's control? Following Frank v. Olson's Cape Breweries, common law grants the tenant a right to a remission of rent if their use of the property is diminished by an act of God, or vis maior. While the common law governs these commercial risks, residential leases fall under the regulatory framework of the Rental Housing Act. Section 16 of the Act introduces the concept of unfair practices and empowers rental housing tribunals to penalize landlords who exploit their tenants, regardless of the strict contractual terms. This brings common law property rights into direct contact with modern constitutional equity. The Constitutional Court navigated this intersection in the 2012 decision of Mapongo v. Angus Lifestyle Properties. The landlord argued that they had a common law right to cancel the lease with proper notice to secure higher-paying tenants, relying on the principle that agreements must be honored. The court disagreed. They ruled that using a lawful cancellation clause with the motive to circumvent rent control regulations constitutes a statutory unfair practice. A landlord's traditional freedom of contract is now subordinate to statutory fairness and the constitutional right to security of tenure. This pyramid maps our progression. Step 1. Classifying the agreement under Westinghouse. Step 2. The common law foundation, where Bosman, Lammers, and Saffiantini provide default mechanics. Step 3. Filtering those rules through the upper tiers, the CPA, the RHA, and constitutional equity in Mapongo. A modern legal practitioner must analyze a contract simultaneously through all three historical layers of South African law. South African contract law has evolved from strict formalism into a system that prioritizes fairness, equity, and the protection of consumer rights.